turn my mic on here. We're going to call this meeting to order, and I want to welcome everyone here. This is the first meeting of this session of the House Judiciary Non-Civil Committee. I see many of you who attend our meetings regularly and some visitors for the first time. We're pleased to have all of you here today. Before we begin, I want to do just a few housekeeping matters. First of all, we have our judge of the day here. I'm assuming you're the judge of the day. Judge Boggs from Waycross, a former member of this house, and we're very pleased to have you with us today, Judge Boggs. We also, since last session, have a new member of the committee, and we're extremely pleased to welcome Representative Matt Ramsey from Fayette County. Representative Ramsey, I'm not sure what you did to make leadership upset with you before you got here, but we're pleased to have you. Let me introduce two or three people I know that probably need no introduction. I can't see them. Sally Fox will be my aide this session. She worked for the committee last year, will this year. Bill Riley does some legal advising for the committee last year and will again this year. Our committee intern this session is Brad Alexander. Where did Brad get off to? Right here behind me. Okay. We're pleased to have a bulldog here with us. And the most important person to do with our committee is Diane Harden, seated to my left here. So we could all not be here as long as she was, and this committee would function just perfect. We have two bills on the calendar today, and we're going to start with Representative Reese and House Bill 301.
Thank you, Mr. Chairman. Can I move all this stuff?
I think you'd have to get permission.
Yes, sir. I'm just proud to be here. So, thank you, Mr. Chairman. I come before your committee this morning presenting House Bill 301. We made it past this level last year and got tied up in rules right toward the end of the session and made a few minor changes. We're working off of LC number 283858S is the latest version. And, sir, with your permission, I'll move forward. Yes, sir. Basically, House Bill 301 is tightening up the current laws on dogfighting in Georgia. I think everyone knows this last year was kind of a wild year. It was brought to everyone's attention when I researched this bill about a year and a half ago. Knew the heinous behavior in the crimes that were going on, and basically was asked to take another bill and tighten up the current legislation, which I did. I got a very simple bill. It's not quite 2 pages long, and I will just start on page 1, section 1. Of course, the definition is just basically relating to gambling offenses and amending the penalties for dogfighting in Georgia. On line 21, or one thing too, Mr. Chairman, what I'd like to do is we have worked endlessly trying to get this bill as perfect as we could and as simple as possible. I had a recommendation just yesterday from a district attorney, prosecutor that's probably prosecuted more dogfighting cases in Georgia than anyone, and he made a simple suggestion as far as just taking out the actual definition that we have used, the specifically talking about the species Canis lupus familiaris, which is a common dog. And as we move through this, I would suggest possibly to, with the chairman's permission, to possibly delete that line of the bill. He just thought it would possibly present problems. Typically in his cases, he said that, you show a picture of a dog, or the assailant, I guess, whatever. Most people understood what a dog is, and defending or going back, trying to prove the Latin term for a dog could be Henderson in his cases or anybody's cases. But basically what we've done in HBL 301 is make it illegal if you own, possess, train, transport, sell with the intent that such dog would be engaged in fighting with another dog. For amusement or gain, causes any dog to fight with another dog, or for amusement or gain, causes any dog to injure each other. If you wager money or anything of value, the result of such dog fighting, then if you turn over to page 2, or knowingly permits any act in violation of the previous paragraph 1 and 2, or if you own, and this is one key too, or if of this subsection on any premises under the ownership or control of such person, or knowingly aids and abets any such act. We've increased the penalties. One for the one actually putting on the dog fighting or owning the property. It was a felony in Georgia up to this point. It will continue to be a felony, but on a second or subsequent conviction, we've increased it from not less than 1 but not more than 10 years in prison and a fine of not less than $15,000. I'll slow down if there's any questions or anything,
Go ahead.
or I'll just continue.
Yeah,
okay.
I'm sorry. Representative Abdul Salam.
I'm sorry, Mr. Chairman. Thank you. I just wanted to have a correction. You said not less than 15,000, but my copy says 5,000.
Yes, ma'am. That's on the first offense.
Okay.
On the second or subsequent offense, it's $15,000.
Thank you.
Yes, ma'am. I'm a little nervous. I've never had so many microphones in front of me, so.
Senator Rogers will tell you how to handle those.
Well, I was fixing to ask for his advice, but I didn't think it was appropriate time. So,
Only because you're my friend, I couldn't resist.
anyway, I'm glad he's here this morning. Also, too, the Spectator, Georgia, unfortunately, had the dubious title of being one of just a few states that actually you could be a spectator at a dogfighting event, and there was basically it's legal. What we've done, and we've talked with a lot of different folks about this. My first intention was to make it a felony on a first offense. Through the counsel of a lot of folks, including the governor's office, we are going to make it, or in my bill, in House Bill 301, we're suggesting that the first offense for a spectator be one of a high and aggravated nature, a misdemeanor. And basically what will happen is the person on the first offense that knowingly attends will not be a felon after being a spectator one time, but the fines are very hefty. It's very similar. It's actually the same fine for a first offense felony, up to $5,000. The criminal offense, or the prison time, I guess you could say, is still 1 year or less. But with the, and I don't have to tell you, learned attorneys, the high and aggravated nature, the good time in that sentence would only be 4 days per 30 of the sentence, versus a regular misdemeanor that could be up to half the time, good time. In other words, serving only half the sentence. That's the first offense on a spectator. The second offense would be a felony, similar to the first offense of conducting a dog fight, which is $5,000. And up to a year in prison, and then the third or subsequent would be the same penalty as the second offense on the if you was actually running the dog fight, which would be $15,000 fine and a penalty up to 10 years in prison. So just in case somebody stumbles up on a dog fight, they would not be a felon the first time. Basically, continuing on, there's a few exemptions. We wanted to make sure, and I've talked with every outdoor group, hunting group, I think, in the state, and we wanted to make sure that this bill did not affect hunters or any outdoorsmen, which I am one myself, and wanted to be very, very particular and make sure we did not cause any problems with the outdoorsmen. And I think our exemptions are very good, and they cover every aspect. We've not had any problem with that from any group. But, Mr. Chairman, that's basically it.
Thank you, Representative Reese, and I want to thank you for your work on this. I know you've worked hard, and this committee passed out this a little slightly different version of this bill last year, and it for some reason that did not make it through the other committee to get on the floor of the House. I know that the leadership of the House has expressed to me and others its determination that we pass a very, very tough bill on this subject matter this session, and that's why we're taking it up on our first meeting. So I thank you for your work, and as well as that of Senator Rogers. Before I recognize the senator, any questions from the committee for the author? Representative Benfield, bear with me a moment to make sure I get the right microphone. Let's try that.
Yeah, it's the light's on.
Okay.
Thank you, Representative Reese. My question, and you may want to refer this to Legislative Council, that's fine, but I have, and this is a larger issue I have with misdemeanors of a high and aggravated nature. I'm not clear how that differs as far as the punishment from a regular misdemeanor punishment. My understanding, misdemeanors, it's 1 year or $1,000. And I don't know if high and aggravated nature allows you to up the amount of the fine. I don't think it allows you to increase that 12 months incarceration. So my question is, how does that differ from just a regular misdemeanor as far as a punishment? And I have another question after that.
Yes, ma'am.
Okay.
I will just read the definition of misdemeanors in Georgia. Of course, the misdemeanor is anything that's not a felony. The high and aggravated nature misdemeanor is basically like a regular misdemeanor, but a high and aggravated nature can be sentenced up to 12 months in jail, similar to a regular misdemeanor. But if you receive a jail sentence, the mandatory good time credit that you get is only 4 days per 30 days of sentence, where in a regular misdemeanor you could get up to half that time, basically taken away for a good time credit. And the fine can be as high as $5,000, which is basically a first offense felony in this bill. So it's substantially more than a misdemeanor, but again, you won't have the felony on your record, which is very important. Especially if you just came to one of these things, or we've seen several examples that we want to be very careful on hammering everybody with a felony on first offense. So.
If I may, and just a follow-up to that particular point, because in your explanation of the bill, you said someone who just stumbles onto a dogfight. I don't understand how you just stumble onto a dogfight.
I don't either. I don't either, but that was brought up actually in this committee, because my first bill was a felony. My first bill was a felony for spectator first offense, and it was presented to me that somebody accidentally kind of stumbled up. But I mean,
I've never stumbled onto a dog fight. I can't imagine. Whoa!
Well, yeah, and if they accidentally bet on the dog too, I mean, yes, but it's a stretch. But that's
one.
We want to be very, and seriously, we want to be very cautious, and again, not make everything a felony. I mean, we're going to have, we have to manage our prisons. There's penalties for felonies that, we just need to be careful. I'd rather be cautious than indiscreet.
Did you have one more follow-up?
I do, and this may be more appropriate for Senator Rogers, but I am interested in how the two bills, Senate Bill 16 and your House bill, differ. And I also want to know, if we vote for this bill, will we quit getting all the emails?
Well,
somebody want to move the question? Representative Mangum.
Yes, sir.
I'm sorry.
Yeah. Well, I could say this, Mr. Chairman, and Representative Stuckey. I think my bill is much simpler. I don't have as many definitions in my bill. My bill's, in no offense, but my bill's not encumbered by any person or group, and I'll leave it at that. I wrote my bill when I first got this copy that had been floating around the house. It was like 7 pages, and I basically just threw it out and started anew. And it's a very simple bill and very targeted toward dog fighting. No dog on animal, no anything except dog fighting, which I think is what I heard people wanted. So, and Senator Rogers can probably
Representative Benfield, I'm going to recognize Senator Rogers in a moment, if that be okay to let him go through. I think he will indicate his views on this bill and can comment on the differences, if that'd be appropriate. Representative Mangum.
You almost answered, Representative Benfield almost answered my question. I am not a criminal lawyer. I did practice criminal law for a little while, but I do not, I'm not one of those who relishes under that area. But I want to follow up on the distinction between the higher and aggravated, and I did notice the 1 to 5 years on the first conviction, and I am a little. How can you receive 5 years on a misdemeanor? And secondly, I say that really,
I think you said $5,000 in 12 months.
I see here where
on the first.
I'm looking at the cheat sheet, and I guess that's what is causing the concern and the problem. So you cannot receive 5 years.
I'm not sure where you got the cheat sheet from. I don't think me.
Well, okay.
So. I'm just working off my bill, so.
Okay.
Yeah, on the bill on page 2, Representative Mangum,
Okay,
on line 10 is where the spectator penalty comes into play.
And it is okay. Let me read it then.
Mm-hmm.
It just simply says any person who is knowingly present only as a spectator at any time for fighting of dogs shall, upon the first conviction thereof, be guilty of a misdemeanor of a high and aggravated nature. I am not a criminal lawyer. Don't know what it means. But down in the second, it makes it clear on the second conviction, I guess. It says 1 to 5. So basically, the felony comes in after the. Am I clear that it's only up to 1 year on a misdemeanor?
Of high and aggravated nature, yes, sir.
Okay.
Yes, sir. According
and
to
I
the
say
definition
that,
I got from our legal counsel.
Okay. Well, that really resolves it because unfortunately, I had the unfortunate. I was invited to something this past weekend, and and I know that. Excuse me.
I rest my case.
It was not a dog fight, but
is this sheriff in the room?
And it really, I probably shouldn't say it in public, but I just want to say that
it's good.
For I do want to cut it short to say that I am concerned about some of my constituents and some of your constituents who just may have stumbled up across something because
there you go, Representative
it
Benfield.
is no. If I'm invited to a skeet shoot, and by the way, they may have some dogs down on the side, I didn't know about that, and by the time I get out of there, rather than me fighting it, I am going to plead, I don't even want to fight it. I'm going to plead, I don't want a trial. So the first offense, I think you should be able to, as a spectator, I don't want to go through the hassle of proving that I didn't know what the heck was going on. I don't want to have to prove. I mean, I was out of a particular room within 10 seconds. But I was in there long enough that if someone came through the door, it's like, whoa. And I can see the headlines now.
I could
and
too.
I'm just trying to say, I'm trying to protect Bobby Reese's reputation. Because if Bobby Reese is in the wrong place under the wrong circumstances, is going to be in a situation where he will not fight. And when most people are accused of a crime, I don't even on a parking ticket, just pay the parking ticket because officer, I was not going X amount, but you go ahead and pay the ticket. And so I'm just concerned about those who do happen up on, and with all of the joking aside, men trying to show manhood in the wrong way may do the wrong thing, but I think this does send a clear message to everyone. This is not tolerated in Georgia, and I applaud your work on it, and thank you so very much.
Well, thank you. If I could comment real quick, Mr. Chairman, and I totally agree. And as heinous a crime it is, I've used the analogy of a drug dealer and a drug user. You can't just punish one and do away with it. But again, we can't, I don't think, in my humble opinion, I'm not an attorney, tell the judges every little move they can make. And so we give them the option of the penalty in the high and aggravated. And honestly, if I understand right, they could not charge somebody. That they could actually cut them loose, especially if they're a representative that happened in that area mistakenly. So, not that would ever happen, but
Skeet shooting.
skeet shooting, yes, sir. Skeet snipe hunting.
Let me remind members of the committee, if you wish to ask a question, please press your button. Representative Setzler and then Representative Abdul Salam.
Mr. Chairman, to the author, and this also addressed to Representative Mangum's concerns. I know we addressed this last year in some detail, and one of the questions that came up was, we certainly want to be able to prosecute folks who are first-time offenders, who are egregious offenders of dogfighting. This person could have been doing this multiple times, and it's on the first offense, you really want to be able to throw the book at them. I think one thing that came out before that I think Representative Reese was sensitive to was in a plea arrangement, I believe there's the opportunity to plead to a lesser charge of cruelty to animals. If for example, the case where causing a dog to fight with another dog for amusement or gain, if it's high school kids who aren't in dog fighting as we understand it, but are encouraging sort of this aggressive behavior among dogs, and it's one person's charge. I mean, there are other charges that can be pleaded to in these contexts that, in reality, the system would take care of itself through some of those means that this $5,000 fine might not apply to if the case didn't strictly apply. But I think Representative Reese wants to make sure that if there are first-time offenses that are egregious, we've got the power in this bill and the strength behind it to prosecute somebody aggressively.
Okay. Representative Abdul Salam, and I'm trying also to get to Senator Rogers here fairly quickly. So,
Thank you, Mr. Chairman. My question kind of follows up on what Representative Setzler mentioned in his comments. One of the questions that I had was whether there's anything that would prohibit jurisdictions that have the pretrial diversion programs in the case of misdemeanors from diverting these types of cases to some kind of treatment, therapy, whatever. Is there anything that would prohibit that if it were available?
Ma'am, I'm not an attorney. I'm not familiar with that program that you just mentioned, and I would give my time to anybody who can answer that question. I'm not for sure.
Thank you. And one follow-up quickly, Mr. Chair. Up on page 2, line 2, it talks about such person or knowingly aids or abets. I guess I kind of like to know in what list you would consider aiding and abetting. If you have teenagers at the house and they're feeding the dogs or they're putting them in and out, is that considered aiding and abetting? How far does that go?
Well, I think you mentioned two different things there: a teenager and someone doing actual
or a wife,
the care.
Or
We got to protect the wives, but I mean that's unfortunate. But yes, we need it broad enough to where anybody involved knowingly. I think the key word is knowingly. If you're knowingly involved in training, feeding, transporting, owning, whatever, yes, ma'am, you're guilty. If that can be proven in court.
Thank you.
So, in the teenager part, yes, we have, and that's the circumstances brought up. Some guy that's really into this, and he brings his teenager. Of course, we got code that deals with minors. So,
thank you.
All right. Senator Rogers, I know the Senate's convening this morning, and I'm going to recognize you at this time. But don't get used to being moved up on our agenda, but we're glad to have you with us. I know you've done a lot of good work in this area.
Mr. Chairman, it's my intention not to be back before this committee again this year, but things may change at some point. Let me, first of all, thank you very much for having me today. I just hope that you'll give me the opportunity to indulge me for just a moment to clear up some things that have surrounded this issue, and I do apologize for what may seem to be a personal indulgence, but I think the situation demands that we clear this up. I got started on dogfighting a little over 4 years ago when a 3-year-old boy was walking from his door inside his own garage to get in his car because his mother asked him to, and he was attacked by a pit bull, who we later determined was probably involved in dogfighting because of the markings. The 3-year-old boy had 8 surgeries on his face, and his mother, who was 8 months pregnant, lost the child. So anyone that suggests that I came up with this idea for any other reason other than to stop dogfighting is wrong. Flat out wrong. In fact, Representative Byrd's husband, who was our commission chairman at that time, renamed a park after that young boy, who will forever not look like a normal young man as he grows up because of what happened to him. And that weighed heavy on my heart as I sat down and spoke to that family. It was at that time that I went and talked to organizations. My first reaction was, let's just ban pit bulls. I mean, that's the reaction most people have. And as I began to learn about dogfighting, which at that time I'd never heard about dogfighting, I began to learn that the problem was not pit bulls, not a breed, but it was evil people doing evil things to God's animals. And that is what this is about. It's not about anything else. And it has been suggested that Senate Bill 16 was derived from all these other things. I can tell you that I wrote the bill myself with the help of prosecutors and law enforcement. If anybody has any evidence to suggest otherwise, I ask them to come before you today and say it in front of these cameras. Right here are the letters that I have received this year alone. This is not last year's letters. This is this year's letters. GBI, Douglas County, Paulding County Sheriff, Warner Robins Police, Chamblee Police, DeKalb County. Hundreds of letters. Every single one of them from law enforcement. So if there's a group that is supporting our efforts here, both Representative Reese and myself, it's law enforcement. And I think you'll hear that testimony today. Now, with that, I wanted to clear up that matter because there have been things attached to legislation that I've brought to this committee that has passed the Senate unanimously that are simply untrue, and those matters had to be cleared up. The fact of the matter is Representative Reese and myself have the exact same goal in mind, and that is to stop dogfighting. That's all. I want to stop dogfighting. I think it's disgusting. I think the torture of pets is something that should not go on in this state. And beyond just the criminal acts that take place at a dogfight, those people involved in dogfighting are going to go on to commit further criminal acts. And these are not the type of people we want in our community under any circumstances. I will be short in my comments on the bill. This bill I know inside and out because it's a great piece of legislation. To Representative Benfield's question, the core of this bill and what's in Senate Bill 16 are almost identical. So much so that I'd be happy to have this inserted in the Senate Bill 16, but I respect the wisdom of this committee and will certainly appreciate sending House Bill 301 over to the Senate. I'll be happy to carry it. And at the end of the day, I don't care what bill gets passed or when it gets passed, other than I'd rather sooner rather than later. And I'll do anything I can to help stop dogfighting in Georgia. And Representative Reese deserves as much credit on this issue as I do because he cares just as deeply about it as I do. So I want to be very clear on that. But what is in this bill and what's in Senate Bill 16 is essentially the same thing. It is our effort to stop dogfighting. There are a couple of things in Senate Bill 16 that are not contained in here that made Senate Bill 16 a little bit longer, and that is just to help comply with a bill that we passed in this body and became law a couple of years ago known as the Mercedes Law. And we had to have some corrections there, and so Senate Bill 16 does include that. And when this comes over to the Senate, I'll probably add that in there just so we can make sure the law is correct. But other than that, this is a very good bill. I fully support it. The only thing I would bring to your attention is with respect to spectators, misdemeanors, and felonies. And I just throw this out to the wisdom of this committee, and you can do with it what you will. Almost every state around us charges a spectator as a felon. Just about every state around us, and most states that have dogfighting laws do that as well. There's a case, Supreme Court case, that someone after me, I'm sure, will talk about in the 1980s that essentially says being a fan or a spectator and being involved in dogfighting is in fact a felony. So an argument could be made on both sides of that issue, but I believe a legitimate argument can be made that this is already contained in case law. So I would suggest, if you're convinced of that fact, that we don't actually lessen the penalty down to a misdemeanor, that may even be beneficial to be silent on it, but again, I'll leave that to the wisdom of this body. But one of the things we did in the Senate bill as it refers to spectators, put an age in there. You don't want a child who's brought by their parent to be caught up in this. And I do think that knowingly present means someone who is actively involved in the dogfighting. And remember this, without spectators, there's probably not going to be dogfighting. That is an extremely important thing to remember, because if you have no spectators and you have no gamblers, you probably don't have dogfighting. And there's all sorts of types of dogfighting: street dogfighting, organized dogfighting, and super organized dogfighting like Mr. Vick was involved in. So there are different types of dogfighting, but spectators are a key part of this. And one last thing to remember about the spectator provision and I think law enforcement would back me up on this, when law enforcement busts up a dog fight, you don't have people jumping to the forefront to say, hey, that's my dog. I mean, all of a sudden, everybody becomes a spectator. So it's important to keep that in mind, that you do need to go after the people that are actively participating in this at these organized events and make sure that they're punished so that they're not involved in it anymore, and the desire to have dogfighting in Georgia goes away. So I'll be happy to answer any questions, and I do appreciate you giving me a few moments here to clear up where we are. I fully support what Representative Reese is doing. I'm 100% behind this bill, and I will assist him in any way to make sure this becomes law.
Thank you, Senator Rogers. Vice Chairman Mumford.
Thank you, Mr. Chairman. Mr. Reese, I spoke with Ken Wynn, District Attorney in the Alcobie Judicial Circuit. In my opinion, he's the foremost expert on the prosecution of dogfighting cases in Georgia, having prosecuted, I think, over 100 such cases. I spoke with him about the concern just a few minutes ago that you raised in your opening remarks about possibly being a problem with the definition of dog as Canis lupus familiaris. His suggestion was and he pointed out that we've had a dogfighting law in this state for many, many years, that there's no real problem with the definition of a dog, that a jury can look at a dog and know a dog when it sees one. Therefore, his recommendation to me was to simply strike your Section A in its entirety, which removes the definition of dog, and re-letter, then B would be A, C would be B, D would be C, and E would be D, the remainder of the bill. I would like to make that amendment, but I'll only do that with your permission.
Representative Munford, I have no problem with that whatsoever. We wanted to
Your
focus
mic's on.
in
Your mic is on.
Is this okay? We wanted to focus and make sure everybody understood what the bill was about, not animal on animal, or and I hear there's hybrid breeds between coyotes and dogs, and I don't even want to get into that, how all that takes place, but we wanted to make sure, and that's why we put that language in there. But if the leading prosecutor in this state says it's not needed, or it might encumber somehow the prosecution of a dog fighter, I'm more than willing to have it removed.
Well, and I think, I'm sure not for you, but for maybe the audience, to elucidate a little bit on the subject, the question would arise whether you need some biologist to come in and identify the animal as Canis lupus familiaris, or even domestic canine. And I don't really think that's necessary. I hope we're correct about that.
Senator Rogers.
If you don't mind me just adding my 2 cents here, I'm certainly for anything to help make the bill shorter, clearer, and more concise. Some of the hunting organizations that I dealt with as we went through this process were concerned with that and wanted to be real strict on that definition, solely for the reason that you do have scenarios where you have a wolf who may have been bred at some point with a dog, and that if you had your dog in a hunting situation go after that wolf, and you just left the term under dog, you could possibly be prosecuted under that. So they wanted to be real clear that we were talking, and that's why that this bill and the bill that I proposed both talk about dog on dog fighting with a specific definition of a dog. I would caution you that if you open that up to a wider definition of dog, that you may get some pushback in the same area that I heard, and they were legitimate concerns that a dog on a hunting a wolf or something along those lines, someone may be prosecuted under that definition. So just bring that to your attention.
Representative Collins and Representative Abrams, did you? Okay. I'm not sure which of you were on first, so let's go with Representative Abrams and then Representative Collins. Is your mic?
Thanks. This just goes into the arcane knowledge I sometimes have. My concern would be that the speciation language for the dogs, my youngest sister is an animal biologist, and this is a very specific definition that would not include the evolution of crossbreeding animals that's happening now. Because when you elongate it to include familiaris, you have really created a very narrow category of domestic canine that doesn't take into consideration any type of crossbreeding. Because once you do that, the speciation really does start to change more dramatically. So I would offer that we do rely. I understand Senator Rogers' concerns, but I do think if you're trying to capture the largest capacity, we run a very strong risk of needing to call in zoologists and biologists in order to prosecute any of these cases.
Mr. Chairman,
Thank you.
may I ask her a question?
Well, we've got a lot of questions up here, Representative
just
Reese.
Real quick, maybe to put this to end, on line 18, term dog means any domestic canine. Would that cover the hybrids and everything? They're still considered a canine, correct?
It's true. When you say canine lupus familiaris, that is a very specific speciation of dog. I mean, you're basically talking about the kind of dogs that you can go and get in a pound. That doesn't take into consideration any species that would be derived from wolf, from coyote, or any dogs that have been bred from that may then be interbred with domestic canines.
Would a dog in a wolf half-breed be a domestic canine?
No, it would not, because the speciation is different. Once you add familiaris, you've changed the species.
No, I'm talking about domestic canine on
Yes,
line
I think domestic
18.
canine
That would
captures
still be-
it adequately.
Okay.
I just would avoid the Latin.
Okay, thank you very much, Representative Collins.
Thank you, Mr. Chairman. Senator Rogers, you mentioned.
Is your mic on?
It was. Is that better? Blinking now. Ready? I'm off again. Okay.
You're on.
I was being loud. You had made a comment concerning the spectator, and you talked about age, and you mentioned the possibility of having an age. Did you have an age in mind, or was that just a comment?
It wasn't necessarily I mean, it's one of those where you just got to think, is it right or is it wrong? And what we put in the Senate bill was 14, but certainly, that's open to debate. But that was the age we used.
Okay, and Mr. Chairman,
Sure.
one chasing this concerning the cannabis. My question and the example that you gave with hunting groups, which I will make sure that this does not involve a legitimate hunting activity, and I appreciate the work y'all both have done. My question is, though, in your scenario, you stated that if you had a dog and you sent it out after a wolf that may have been bred, does that fall completely out of the spectrum of what possibly your bill and this bill deal with under the bedding statutes, and the fact that or is there certain scenarios that they're looking at where they're bedding on my animal in a hunting situation? Can you clarify your?
Well, I would never interpret this law to mean that could ever be part of dogfighting. But those who are engaged in those activities had a concern that a zealous prosecutor could interpret it that way, and that's why they wanted to make sure they cover themselves. I can't imagine anyone doing it, but then again, we want to err on the side of caution.
Chairman Knox.
Mr. Chairman, thank you. This is probably a question for Legislative Council. If, with respect to the punishment part of this, can anything be included in that with regard to restitution by the offenders for the cost of caring for the animals that are seized in this case, or that are found, let loose on after they've proven not to be successful or effective or whatever? Because I know they end up oftentimes being cared for forever because they're too dangerous to be allowed at large or to be cared for just anywhere. And I haven't seen anything in either one of the bills with respect to that. I know it's kind of late in this process, but I don't like the idea of us letting these morons dump this problem of taking care of the animals afterwards on us after they've made a profit on doing it, and train them and putting them in the condition where they aren't able to be maintained anywhere.
Can I comment on that, Mr. Chairman?
We have another bill, and we have people signed up to speak.
Yes, sir.
So I will leave that to if you want to. We're going to talk about this one a while longer, and
Yes.
If we don't finish the discussion today, we'll carry it over.
The reason, if you look on page 2, line 18, any dog subject to fighting may be impounded pursuant to the provisions of Code Section 4-11-9.2 through 9.6. We felt like that was covered under there, that there is enough, we think, law to cover any animals. Are you talking about just turned loose by the owner or confiscated and then
Either one, because
released? Yeah.
either way, the community ends up having to deal with the animal some way, and it's not the animal's fault that some moron taught it how to kill other dogs, and it's now not it's not acceptable to have it loose in the community, or it can't be cared for in a as an adoption or something like that.
Vicious dogs are defined, and I think they have the option to do whatever's necessary to make sure they don't hurt the public. But again, that's kind of out of our hands once the.
I guess my question to the Leg Council was whether or not that can be included in the code with respect to that restitution element, because it can be pretty expensive to either rehabilitate and or maintain an animal that's been trained like this. And I understand there's more than just a few of them. That's be pretty costly for the Humane Society and the local community.
Well, two of the Vic dogs are actually coming to my district. I did not request that. But a lady in my district did, so I'm concerned. Yeah.
Maybe we can. I'll reserve the question. Maybe Leg Council. You got it. Okay.
Damages. Looking at the restitution chapter in Title 17.
Right.
And damages means all special damages which a victim could recover against an offender in a civil action, including a wrongful death action, based on the same act or acts for which the offender is sentenced, except punitive damages, damages for pain and suffering, mental anguish, or loss of consortium. Such special damages shall not be limited by any law which may cap economic damages. Special damages may include the reasonably determined cost of transportation to and from court proceedings relating to the prosecution of the crime. So you can see.
So the court has the ability to impose that. Some of those related costs are consequential costs, I guess. So, I guess that's how they got Vic to agree. I don't know. I don't know if that was a plea deal or if that's actually coming from the code. Oh, that's federal code. That's right. Yeah.
Okay.
Well, that may be something we can't resolve right now. We could probably talk to the authors after this and see who wants to help on that. I guess, Mr. Chairman.
Thank you, Representative Benfield.
Thank you. My question was prompted by some of Senator Rogers' comments about children being brought to these dogfighting events, and of course that's a real concern to myself, and I'm sure everyone else in the room. Did you consider putting into your bill a provision that would add an additional penalty or fine or some other level of punishment for bringing a child to the event? I understand where you wouldn't want to punish the child, but enhance penalties for bringing a child.
We did not. That is a fantastic idea, and of course I'm not the author of this bill, but I would certainly support that being added to it. If you bring a child to it, let's throw the book at you even more.
If I just ask, this is more of a logistic question. It would be helpful to have a copy of Senate Bill 16 in front of us. Is it in the packet and I'm just missing it?
It's not in the packet because it's not on the agenda.
Okay. I would like to be able to compare the two and see where y'all might be willing to come to an agreement. If there's any possibility, instead of it going through a conference committee where you may work out these differences and we have, a few minutes on the House floor, is there any way we can get this cleaned up in our committee?
I think Senator Rogers will speak to that.
I'm in full agreement with House Bill 301. We won't. It is my desire not to go to any type of conference committee. If this alone were all that was passed, we've made a giant step forward. So any improvements I welcome, and I can't speak for Representative Reese, but I believe we're both on the same page, and we're fully united behind seeing this bill right here become the law of the state of Georgia.
Let's see. I think Representative Setzler was next.
Mr. Chairman, at the appropriate time, I'd like to be recognized and make a motion.
Okay, I hope to get to you very quickly, and I will come back to you. Vice Chairman Mumford.
At this time, I'd like to make an amendment after consultation.
Hold amendments until we get a little further in the process. Secretary Bearden.
It's not really a question. Just want to make a comment. If you take a child to one of these events, there are numerous charges that could be levied for child endangerment, child cruelty, all those other issues. So, as the Vice Chairman said, those items are out there to make sure punishment could be given if that's the case. And I'd love to second the motion when we get to it.
Okay. You'll be recognized at the appropriate time. Okay. Representative Benfield,
I just wanted to add that I do understand. I mean, we worked on the child endangerment statute in this committee, or maybe it was in the other judiciary when I started on that committee, but I'm familiar with that. But a lot of this is also an educational effort, and to have something specific about bringing a child in this bill would help get the word out that it's inappropriate to bring a child. I mean, certainly people should know that, but I don't know if I have time to draft an amendment that would work on such short notice anyway, but I do have a concern about that.
okay. Representative Abdul Salam.
Thank you. Just a question, maybe for some of the lawyers on the committee. Would we be able to attach that penalty under the child cruelty law or child endangerment itself for carrying them to the dog fights and seeing that brutality?
One of y'all want to answer that?
Well, I think if we start, I think it was covered, and that's why we did not put it in the bill. That aiding to the delinquency of a minor. I mean, there's a lot of laws out there already on the books that, and I don't know, if we need to specifically start trying to amend that code. But again, I'm not an attorney. I'm just kind of looking at it, because then we're going to have this exhaustive list of offenses against minors, and what if we leave one out? Then I think it's okay. I remember looking at the code because we're very concerned with minors. I'm raising my grandson, and I'm real concerned he don't stumble up on a dog fight, especially with me with him. And I'm going to make sure that doesn't happen. But I'm very, very concerned about the children. But again, sometimes I think we can make things so pointed that we actually lose some value or lose some people on the side. Does that make sense? But we did look at that code. Yes, ma'am.
Okay. All right. Now, we have about 5 people who have signed up. Do all of you wish to still be heard before we move forward in whatever action we take? David Waller, Georgia Wildlife Federation.
Can I just say the sporting community, the hunters and fishermen support this bill, and we also support the amendment.
Any questions of Mr. Waller? Frank Rotundo with the Georgia Police Chiefs.
Mr. Chairman, Frank Rotundo with the Georgia Association of Chiefs of Police, representing 572 police chiefs. Thank the authors. Well done.
Okay. Any questions? Carolyn Denise, I may not be pronouncing that correctly. Well, good. Humane Association of Georgia.
Thank you, Mr. Chairman, Committee, and Michael Vicks for getting this hearing so quickly in place. My name is Carolyn Denise. I'm the president of the Humane Association of Georgia, and we are a coalition of humane societies, animal control, and rescue groups, and one of our first members was the Georgia Animal Control Association. We strongly support this bill. We might want to consider just a couple of things. We'd like for it to be called the Prohibit Dog Fighting Bill. Otherwise, it might look like another revenue generating type of bill. So hopefully we might want to start naming it for what we're trying to do, which is, prohibit dog fighting. We certainly would like the idea of it including all animal fighting. That would eliminate a lot of our problems with definitions. And then felons in Georgia would know when they're felons. I mean, it's by case law. It is a felony to fight chickens in Georgia. In DeKalb County, we fight fish. We would like to get rid of the illustrative list of what is. We'll talk. We would like to get rid of the illustrative list of what is not prohibited. We all know that hunting and certain agriculture, activities are completely legal in Georgia. So we don't feel like there's any reason to constantly, repeat what is already legal, since we know that. We did agree with the idea of fining for children, just because we really want it very, very clear quickly in terms of, not bringing children, to such activities. Especially with the all animals, it handles all of the hybrid issues, because if we get into a definition where some type of hybrids are allowed, then all you're going to do is generate, there are people in this state that will just spend a whole lot of time trying to breed these hybrids, and it's very difficult to manage them. They're not allowed in animal control. They're going to be automatically killed. It's pretty hard to find them homes. We're still killing 100,000 animals in Metro alone every year because there aren't enough homes for them. I want to remind you that dogs are the weapon. We'd like to see certainly that they pay for them being held. Right now, it is true there are other ways of getting that money back, but you have to provide notice. There has to be a hearing process, so it is a very difficult process to get that back. We do want to see that the animal be spayed or neutered and chipped before it's returned, because then if they actually want the dog, that will be okay. If they just want the fighting machine, then they will have it euthanized. So we would like to see that coming back to concentrating on the dogs. Thank you.
Thank you. Any questions? Thank you very much, Ms. Denise. Mo Thrash, Humane Society of the United States of America.
Thank you, Mr. Chairman. Ladies and gentlemen of the committee, I'm Mo Thrash. I'm representing the Humane Society of the United States. And I'm here this morning, first of all, to thank Representative Reese and Senator Rogers both for their input into dog fighting. This is no new deal here in Georgia. Just because of the case of Michael Vick brought it public, it's no new deal. We've been working on this. I have, as an individual, for 4 years with Senator Rogers. Senate Bill 16 passed the Senate last year unanimous. Representative Reese has been working on this for a year and a half. It's nothing new. I want it perfectly understood that the Humane Society of the United States is 100% in favor of this bill, because it has nothing to do with hunting. It has nothing to do with game management. It doesn't want to impede on anything but dog on dog, fighting dogs, to outlaw it in this state and make it prevented for no one to be allowed to participate or be involved in dog fighting. So I commend this committee, and I thank the chairman for bringing it up so quickly and trying to move it on through the process so we can get it to the governor's desk for signature and make it law in this state where no one, and I mean no one, will come to Georgia and participate in dog fighting. So thank you again, Representative Reese, and thanks Senator Rogers, and thank you, Mr. Chairman, your committee. We appreciate it.
Thank you, Mr. Thrash. Any questions? Chair recognizes Representative Setzler.
Mr. Chairman, I'd like to thank Representative Reese again for working so hard on this bill. I'd like to offer an amendment. Are you entertaining amendments this time?
Why don't you make your motion, and we'll get a second, and then we'll take up amendments.
Mr. Chairman, I'd like to recommend due pass for House Bill 301.
We have a motion that House Bill 301 be given a due pass recommendation. Is there any discussion? Vice Chairman Mumford.
I'd like to offer an amendment after further discussion and after consideration by the committee. We would leave paragraph AN as numbered, which would not require a renumbering of the paragraphs. I would, at the point in line 18, after the word canine, I would insert a semicolon. I would strike the words, "that is a member of the species Canis lupus familiaris," period.
Jill.
Period. Let me restate my motion. The term dog means any domestic canine, period.
Second.
All right, we have a motion, an amendment by Vice Chairman Mumford that's been seconded. Is there any discussion on the amendment? Any discussion? Is there any opposition to the amendment? Hearing none, that amendment is adopted. Any further discussion? Any further discussion? Any further? Is that Chairman Franklin?
Thank you, Mr. Chairman. I want to commend Representative Reese for the efforts, and Senator Rogers as well. I believe dog fighting is a heinous offense. That is cruel. Senator Rogers did mention the motivation that got him started was when a dog mauled a human being. And as I supported this bill last year and opposed even weakening the penalties for spectator, I'm reminded more in the last year, however, of what is the purpose of government. And it's to, as our founding fathers told us in the Declaration of Independence, it's to preserve, protect, and defend God-given rights. And we know that that is defending people. And we're reminded in God's Word in Proverbs 12:10 that a righteous man has regard for the life of his animal, but even the compassion of the wicked is cruel. And while there are other jurisdictions that God has placed us under besides civil government, just as this room has 4 walls, there are 4 spheres of government. One is civil government, and that's what we're taking part in today. There's church government, there's family government, and there's individual government. And so often we tend to think because as the civil government, because we've got the money and because we've got the guns, we can interfere in other realms. But it's the purpose of the civil government to preserve, protect, and defend God-given rights, and those are human rights. And that is not something that this bill deals with. Punishing someone whose dog mauls a child, that would be one thing, but this one is not one of them. So I'm going to have to reverse my position from last year.
Okay. Thank you, Chairman Franklin. Further discussion? Further discussion? As I understand our posture now, we have a motion to give House Bill 301 a due pass recommendation and as amended by committee sub. Is there further discussion on the motion? Hearing none. All in favor of giving House Bill 301 a due pass recommendation by committee sub as amended, please indicate by raising your right hand. I'm sorry. LC number 283858S. As amended. As a sub, I'm sorry. Okay. Okay. All in favor of giving House Bill 301 a due pass recommendation by committee sub, please raise your right hand. Did you get them? Okay. All opposed? Okay. Representative Reese, thank you for your good work, and Senator Rogers had to go on. This is a very, very important issue and a good piece of legislation. Thank you.
Thank you, Mr. Chairman.
All right, can I have your attention, please? We're going to take about only a 2-minute break to allow the orderly departure of those who came maybe only on 301 and kind of get reorganized, and then we're going to take up House Bill 908.
while we're waiting for the members to return, my classmate from the University of Georgia Law School, Ms. Velma Tilley, who is the Bartow Juvenile Court Judge, is here today. Good to see you, Ms. Tilley. All right, I think we're ready to proceed. Ladies and gentlemen, we are going to be taking up House Bill 908. The chairman of the committee is the sponsor of that bill, so as the what am I?
Did you press my button? I think you're the vice chairman.
As the vice chair,
Mr. Vice Chairman.
I'll be conducting the meeting. Thank you. Mr. Chairman, would you take us through the bill, please?
Thank you, Mr. Chairman, and thank members of the committee for staying around after the break. And I will try to be as concise as possible because I know that we have session beginning not too long off and lunch and other considerations. In 2006, this General Assembly overwhelmingly passed a law that both enhanced punishment for sexual offenders in Georgia and sexual predators, as well as imposed certain restrictions on those people in terms of where they could live and work. We did that to protect children in Georgia. We took the lead, I think, in response to some tragic cases that had happened in Florida and in Idaho and other places, and joined many other states in enacting enhanced punishment and these restrictions. Georgia adopted one of the toughest laws in the nation, and I think it was one that, although it generated a fair amount of controversy, change often does, I think it was a good law. We're here today, Mr. Chairman, because in November of last year, the Georgia Supreme Court essentially struck down the residency restrictions by finding that there was not an exception in those for certain offenders. And on a set of facts, basically struck down all of the restrictions in the case of an individual who had purchased and owned a home and had complied with the law, and then had one of the facilities that is in the restricted area move into the zone after his purchase. The Supreme Court viewed that to be a violation of the Takings Clause and voided that. I respect the court, but we're here today essentially asking this committee, and we'll be asking the General Assembly this session, to reinstate the residency restriction that we do not have currently in our law. House Bill 908, which I'm joined in bringing before this committee by the majority leader of the House, many members of this committee, and others, is a very narrow and tailored bill, and it essentially does a few things, and only a few. Number one, it does adopt what we call, or what other states have referred to as, the move to the offender exception, and makes exempt those individuals who purchase a home, move into that home in compliance with the law. Because when they do that, they're outside the restricted range of those areas that we have decided as a matter of policy in Georgia that they're not to live or work in. If you're there, if the offender is there first, that offender is exempt by the ownership or purchase of a home. I'll come back to that in just a moment. It also adds to the list of places, and this came at the request of some local governments and the governor's floor leader. It adds to the places areas where minors congregate, public libraries. This was apparently a concern, I know, in Chairman Franklin's county, among others. to have these individuals kept away from there. We also have adopted some suggestions made by the Georgia Sheriff's Association, and I will come back to their other suggestions in a moment, by basically clarifying that an individual, we have a prohibition in the law now, which was the constitutionality of which was sustained by the Supreme Court on the work restriction, but it also now includes volunteer, to say that a person neither can work or volunteer at certain of these locations. It clarifies how we measure the distance from an individual's property to these places, because there was a little bit of discrepancy in House Bill 1059 as it was passed in terms of measuring both for residence purposes as well as for employment purposes. It provides the kind of proof that one needs and gives guidance in terms of the proof needed to establish residency and being exempt from the operation of the residency restrictions, and that's essentially what it does, Mr. Chairman. Let me comment before I finish and answer questions on two or three things that have come up. I know that some members of the committee, including the vice chairman, have been a very strong advocate of Senate Bill 249, which was some suggestions passed by the Senate last year, some suggestions made by the sheriffs in Georgia. We have incorporated a good number of those in this bill, trying to keep the focus of this bill as narrow as we can. I know Vice Chairman Mumford has a lot of interest in seeing that bill move along in some other areas, and I have indicated to him that we will be giving that bill a full and very active hearing in the not too distant future. And the reason I thought we didn't really want to address all of those things is because really many of the issues covered by 249 were outside the scope of what the Supreme Court ruling really did. There's also been some discussion, and I'm just going to tackle this one head on. I know there may be a question or two about it, about renters. And I want to tell you that staff and I have looked at other states to see what other states have done, to see if there is a workable way that we can include that provision in this bill. And I can tell you that the other states, we could not find any state that really included an exemption for renters. Renting and owning are different concepts. Renting was kind of the issue in the first Supreme Court case involving the same individual. The case that was decided in November involved an individual named Mann, and it was his second visit to the Georgia Supreme Court. On the first visit, he was a tenant, and then in the second visit, he had purchased and was owning a home, and it was under the takings clause that the Supreme Court really rested their decision. I think if you read that, you will agree. So we did look at that. I think there's really no way of effectively doing that without having that exception basically swallow the rule. And finally, then there's been I know some discussion, and this also, since it's a new law, is to be expected about how we categorize people and those people that we require to register as sex offenders based on the offense for which they are convicted. And I know many people have an interest in pursuing that. When we met on this bill and went through this bill back in December, it is true I said that that's a fair discussion, I think. But by the same token, I've indicated repeatedly, and I will indicate on the record today, Mr. Chairman, that if someone wants to incorporate those concerns in a bill and bring it to this committee, we will hear that. But again, I think to reopen that, reopens the entirety of 1059, and this bill is that I've prepared and offer to you today, I think is much more narrow in its scope. That's my objective. I am willing to have that discussion at a later time. Mr. Chairman, I think the issue is very simple. Georgia was a leader in 2006. I think with, and I stand corrected, Sally's here with me, I think every state that is adjacent to Georgia, with one exception, has adopted residency restrictions, and now we don't have residency restrictions. And I think if you believe that Georgia's parents and grandparents want this protection, then I would ask for you to vote for this bill to send it on to the full House for its consideration. And so with that, Mr. Chairman, I would yield for any questions.
Questions from the committee. Mr. Knox, is that a question from you?
That would be Mr. Chairman. Mr. Chairman, and it may not, and I understand this may not be in the purview of this particular bill, and it will probably have some other bills addressing issues in connection with with that bill. The one thing that I'm concerned about, and I'm not sure whether it's in here or not or needs to be, but I'm sorry. Okay, I'm not sure whether it needs to be or not, but with respects to this whole issue of residency, one of the things that concerns me is I'm more concerned about where the victim lives than I am about where the offender lives. And so, because oftentimes the victim is somebody that, may be in the house, maybe somebody that lives in the neighborhood, that sort of thing. So I'm not sure whether we're addressing this in this bill or if we intended to, but I hope that if we don't, sometime we get around to doing that, because I think that should be the paramount issue for the court and for the community, is not having the victim have to go somewhere else to get away from some offender like this. I don't care whether they owned the house, didn't own the house, they're a renter, or they're camping, or whatever the hell they're doing. Wherever that victim is, I think if they live there, that should be the primary consideration for us.
Well, and I appreciate your comments. This bill doesn't address the victim in terms of mandating where the victim can live or should live, but it's designed to protect, obviously, the victim and to protect against other victims. I wish we had as much concern for the victims of these crimes as we've had from some quarters for the offenders. But frankly, we haven't, and that's what this bill was about 2 years ago, and that's what this bill's designed to do.
Thank you, Mr. Chairman.
Ms. Abrams, is that your?
Yes. Mr. Chairman, I have just a couple of questions just to find out if this was considered. Two of my concerns are, one, whether this applies to college students who live on campuses that maintain daycare facilities, and if they are residences of those schools, will this require that they cease to live in those residential halls?
Well, there's not an exception. We did not. You can look at various scenarios, and we looked at as many scenarios as we possibly could. I think if we have someone on the registry, they're not going to be able to live within 1,000 feet of a daycare facility, as this bill is now proposed.
Okay. And the second question would be court-ordered rehab facilities or court-ordered locations. If those places, in particular, I'm concerned about the areas where minors congregate, because we've expanded it to include a number of public facilities that are typically co-located with other public facilities or with other areas that have been zoned for public facilities. Whether or not we have considered what happens if there's interference with a court-mandated action by an offender, if they run into opposition with this. Is there a mechanism by which they can appeal or somehow avoid violating one law in order to comply with a second?
Well, I think the court would be free to craft its orders in terms of rehab facilities as it chose to do. I mean, I don't think there's anything in here that would take away their ability to do that.
Okay, thank you.
Any other questions for the chairman on this bill? All right. Is that Roberta?
Thank you, Mr. Chair. Just I guess more clarification than anything else. And I raised this 2 years ago. But there's so many places where minors congregate. I noticed that we still don't have hospitals here. Does that indicate that the predators can hang out at the hospitals? And I'm too very concerned, as I was before, about coming up with the way on how we define who is truly a predator and who made a mistake. So that way, I think that if we could delineate who's a sexually dangerous predator, because right now we don't have that in place, that might help some of those concerns.
Let me answer your the second part of your question first, if I could, and that's, and I think what you're touching on there is this notion of who we require be registered and who we don't require, or how we categorize people.
Right.
And that was the thing, the issue that I commented on earlier. That I acknowledge that there is some concern out there, and there have been some discussions about we need to change that. And I'm as speaking now in my role as chair of the committee. If someone wants to bring a bill on that, then it will get a hearing. But I didn't think it was appropriate in responding to this that to reopen the entire law because some of the law was upheld. The law that was being challenged, a part of it was the constitutionality was upheld. The second thing was that in the area of where minors congregate, we have a definition in the current law, and it has areas that we looked at, and came up with a definition of places that were unique to children. Libraries, schools, daycare facilities, swimming pools, I think were in there, things of that sort. So I think that, while it would be true that children obviously have to go to the hospital occasionally, I don't think there's anything really unique about them having a lot of them congregating there.
Unless it's a children's hospital.
Unless it's a children's hospital, and I'm happy to have that discussion with you.
Okay, all right. And one follow up. I'm also concerned about the provision for renters, and trying to figure out a way to address that, because in many communities, especially with the economic situation we live in now, we have very many renters or people that are having to rent more than we had before. And I think that if the renter who happens to be on the registry is already there, then the same provisions should uphold to the renter if they were already there. And as we know, many times renters are transient. So could we look at something like if the renter was already there or established there for a certain period, but if they moved, then they've got to consider that.
Representative, we looked at that entire area. As you touched on, renting is not only more transient, but it's also less clearly defined or less clearly established by the law. If you own a piece of property, you're going to have a deed to it. And owning property, there has to be evidence in writing of that, and there has to be some evidence that of that being your residence. A rental agreement can be verbal; it doesn't even have to be in writing. And so, we're, I think, then putting on the sheriff's departments the function of determining the validity of lease agreements, whether they're actually valid or not, whether they're in writing, for how long do they have to be. The Supreme Court, we were trying to respond to the Supreme Court decision, and the Supreme Court decision had before it the issue of renting in the first Mann case. It had the ownership of property before it in the second Mann case, and it talks about a reasonable expectation of protecting an investment, and they use that language at least twice in that opinion that I recall. in the second decision. So I think that and by letting their decision rest on the takings clause of the Constitution, it is our perception that they were much more concerned about ownership than renting.
Who would be responsible for the measurements, doing the measurements for distance determinations?
I think as an initial matter, it would be the sheriff's office.
Okay. Thank you, Mr. Chair.
Do you have a question? You have a motion? All right, we have some people signed up to speak to this bill. I'm going to call on them. Mr. Jerry Weber. If y'all can just stand there, that'd be fine. Speak loud enough so everyone can hear, please.
Chairman Ralston, Vice Chairman Mumford, members of the committee. My name is Jerry Weber. I'm Senior Staff Counsel at the Southern Center for Human Rights and one of the lawyers on the class action lawsuit of Whitaker versus Purdue, where we represent 14,500 persons ranging from teenagers who had consensual sex to people who were convicted of serious sex offenses. And we, in the wake of the Mann decision, have been trying to evaluate how broad its scope is, as has the Attorney General's office, as has the Sheriff's Association. And Mann said, the second Mann case, it is apparent that there is no place where a sex offender can live without continually being at risk of being ejected. So we're going to really focus in on whether the Mann decision impacts only owners of homes or others, including renters. And there's a whole gradation going from owners who have a deed to people who have a mortgage and don't have a deed down to renters. And actually the first Mann decision went to somebody even below a renter, because this was a person who didn't even pay rent but lived in a house. And that was the reason why the first Mann decision found there was no taking. Now, does the takings clause apply to renters? 62 years ago, the U.S. Supreme Court said yes. 6 Georgia cases say yes, that the takings clause is triggered for renters as well as homeowners. We are, as I said, litigating the Whitaker case still in federal court. We believe that the fix isn't big enough and that this law will be struck down by the federal court based upon those old decisions, 6 decisions from the Georgia courts. We believe that this law will be struck down. The Attorney General's office and the Sheriff's Association have both issued written opinions that say that they believe that the Mann decision means that the residency restrictions are no longer in place. No longer in place for owners, no longer in place for renters. We would ask that this committee hold off. Let the federal court figure this out. There's going to be motions before the federal court very soon. And if the federal court does it in a way that leaves some room where the legislature needs to act, then the legislature should act. But give the courts the time to wrestle this out. It's complicated questions of property law and constitutional law, but we think the constitutional questions, at least for renters, are pretty clear. Thank you.
And Mr. Chairman.
Ms. Tatanchi.
Thank you. I'm Sarah Tatanchi. I'm also with the Southern Center for Human Rights, and I do have a few handouts for the committee. Sorry, I didn't push it quite far enough over. I just want to comment that with the exception of my colleague here next to me and a few others, the Southern Center for Human Rights is very much a firm made up of women, and we share the chairman's concern in making women and children more safe. We would strongly encourage the members of this committee and legislators across the board to look seriously at the issue of residency restrictions and whether or not they truly are effective in protecting women and children. The Georgia Board of Pardons and Paroles have done numerous studies on recidivism, and 2 of the things that they found that most strongly impact somebody reoffending and committing another crime like this is change in residency and change in employment. 2 things that these residency restrictions and the employment restrictions do is exactly that. Make people change their homes and addresses and make people lose their jobs. Another thing that these residency restrictions do is that it limits the areas and towns where people on the registry can live and creates clusters of sex offenders.
which can be more cumbersome and more problematic for people to deal with. It also has the unintended consequence of forcing people on the sex offender registry to go underground and fail to register. And at that point, nobody is supervising them. Nobody knows where they are. And our ability to keep track of them and their activities dramatically decreases. So I would just ask y'all today, as a daughter, as a sister, as a friend, and as a woman here, to think seriously about doing real, meaningful things to protect women and children in Georgia, and perhaps revisit the idea and look really hard and see whether residency restrictions are helpful or counterproductive to public safety for women and children.
Thank you. Question from Mr. Bearden.
Not a question, more of a comment. Chairman Ralston, I just want to say, as part of the legislative branch of government, I appreciate you taking the lead in protecting our children now and not waiting around for the federal government, and for bringing this legislation forward. And when I say federal government, I should say the federal courts, who has a job to do also. But thank you for bringing this forward and protecting our kids today and not waiting on them.
Thank you.
Further question or comment from, is that you, Mr. Mangum? I believe I've got your turn.
Yes, thank you, sir. Mr. Chairman, I want to thank you for bringing this legislation. And I basically thought that you were clearing up an issue, but then, with all due respect to our chairman, I heard this rental issue, and then I am a trained lawyer, and I do know a little law. And it really struck me that the Constitution does prohibit you have the right to contract. And I agree with your legislation, let me say that. But I am concerned that if, as a jurist, which we have a balance of powers, we're the legislative, of course, that my distinguished non-attorney to my right may have a point, and that is, you can orally contract with anyone. It will be a matter of proof whether you did have that existing right to contract. And as the distinguished Mr. Weber, is it Weber? Right. Mr. Weber brought out that there is some other law from 62 years ago or whatever. But I am understanding that the constitutional right to contract may throw this out again, and we all want to make good law. And you may or may not have looked into this, but I didn't think of it. I only responded to what the court, now you may have just responded to what the court said, because there is a taking of, I can understand their reasoning about the taking, but I'm also looking at the right to contract. I have the right to make a contract with anyone in here, and a third party has no right to interfere with that right to contract, as long as that is a right to contract. So if you looked at this, I know it's a narrow legal issue, but if there was someone there, say at least a year before, they have to have notice and then move or something. I just want some, and I know that that'll cut on both sides and not going to make everybody happy, but where there's a rental situation, I think we have the right to balance the rights of these victims, and I am a proponent of protecting our ladies, because I think I'm against all the terror and the fear. We got people in so much fear, it's ridiculous now. My wife says she doesn't even want to walk around Stone Mountain Park. We do that all the time. But what I'm trying to suggest is, I don't want a law to go up and be thrown out again, and so if you looked at it, or has Legislative Council looked at the right to contract being infringed when there is a pre-existing rental contract and a person moves into that area after they've already contracted, and we may even have some timetable even in the legislation so that it is not a clear infringement on that contract right, but that we have balanced and we have taken that, and I think we have the right to modify that right so that anybody from here forward would be on notice that if you enter into a rental agreement and you're a sexual predator, or and that's really what we want to focus on, the sexual predator, that on a year's notice you're gonna have to move, or on 30 days' notice you're gonna have to move, if you knowingly. I don't know how to frame it, but I'm just suggesting that we need to not fall into another area where it'll be stricken, and I can see that being stricken. And I represent people that rent as well as people that don't rent, and they have equal rights under the Constitution. They're just different provisions that may protect them. So if I would just ask the chairman, with all due respect, to let council, if you've already investigated it, that's one thing, but if you have not, could we at least examine that, because I can see that may be a problem. And if you've thought about that, or have you not thought about it? 'Cause I just thought about it. I just put that together with what he said. Other than that, I didn't even have a question on it. I said he's correcting this problem, bam, and let's just vote on it. But I am concerned about that right to contract.
All right, we have some other people who have requested to speak. Ms. Abrams, I think, was next.
I just had a question for Mr. Weber.
That was too lengthy.
Any research into the number of elderly offenders who are captured by this law? In particular, I'm concerned about the Medicare requirement that usually requires forfeiture of personal property if you move into supportive housing, and the fact that if they are forced to leave those locations, they no longer have anywhere else to go to. Does your lawsuit contemplate, or does it provide any research on the number of offenders who would be captured under these provisions?
I'm not sure that we have the numbers. In the litigation, we actually filed a separate injunction request on behalf of a series of persons who were in nursing homes and who were in serious medical conditions. And thankfully, the sheriff's upwards of 50 people is the numerical answer. And thankfully, the Sheriff's Associations agreed to limited injunctions to ensure that those folks who simply couldn't move weren't forced to be prosecuted. But it's still a pending issue in the lawsuit.
Thank you.
Representative Stuckey Benfield.
Thank you. I asked Chairman Ralston this question when we reviewed the proposed bill, I guess last month, and so I want to ask it again. I'm sorry if y'all made this in the presentation to Sarah and Jerry. Is there any data, any studies, any research indicating that these residency requirements are effective in reducing sex offenses, crimes against children, crimes against women? Is there any data out there to suggest that this is an effective way to prevent crime?
Somebody who's going to testify after us is Kevin Baldwin will speak to that further. But just to repeat what I said, the Georgia Parole Board has found that every time that somebody changes their address or employment, their likelihood of reoffending goes up 25%. This law forces people to move and lose their jobs.
And our written statement has some statements from a number of sheriffs and law enforcement officials who express their concerns about people absconding as the result of the legislation. And we all know that's the most dangerous situation, when somebody's no longer reporting and they're out there, but we don't know where.
All right, I think we had someone over here. I'm not sure who it is. Yes, sir. New representative.
Am I working this? Okay.
It's a little hot, so you might want to back off of it.
Mr. Chairman, I want to make a comment more than anything. I just want to thank you. I'm one of those Georgia parents that send their children off 2 days a week to a preschool, and I appreciate all your work on this. I think we need to put every tool possible in the hands of law enforcement, prosecutors, and judges to protect our children and our communities. And I want to specifically address this renter issue that my First Amendment professor from law school, Mr. Weber, addressed. And I think he made the point that there are certainly degrees of property rights, ownership down to renters. And I do litigate a little bit in this area as an eminent domain attorney. And I think the Mann case specifically talked about the burden placed on owners of listing agreements, paying real estate fees, all the burden that comes with selling your property that's not present in the case of a renter. I think this is an appropriate response to the Mann case. I appreciate your work, and I certainly support it wholeheartedly.
Thank you. All right, I had a question from Mr. Levitas.
Thank you, Mr. Chairman. And you
cited that study by the parole board. Was that Department of Correction? Did they elucidate with any explanations as to not just the statistic of somebody moves, they reoffend, but what might be the causal link between those two?
I think that's another thing that Kevin Belkin will testify to.
Okay. Thank you. Thank you, Mr. Chairman.
We'll move on then. Thank you very much. We'll move on to Mr. Baldwin. I think he's next on the list.
Chairman, Vice Chairman, committee members, thanks very much for giving me time to talk. I've got some handouts as well. I'm here for two reasons. First off, I'm an expert in the research and treatment of sex offenders, but secondly, I'm a father. I've got 3 children of my own, ages 5, 8, and 10. So I've got a real vested interest in the protection of children and the reduction of childhood sexual abuse, both from a personal and from a professional standpoint. As a researcher who's worked in this area for about 15 years, I found that there's a number of things that we can do, that research has found over a number of years, that actually are effective in reducing childhood sexual abuse and sexual victimization of women and children. And in your handout, I've listed a number of them in terms of things that can be done from a legislative standpoint, as well as things that can be done from a management standpoint. Because after all, we're doing the same thing. We're after the same goal. Everybody here wants to reduce sexual victimization of children and women. You do it from the legislative standpoint, I do it from a research standpoint, from a treatment standpoint. So we're on the same page. There are many ways that we can do that effectively that have proven track records in terms of their effectiveness. However, I believe that residency restrictions and other similar legislative efforts actually have the potential to undermine those ways that we've learned in over 50 years of correctional science can help reduce reoffending. What I want to do today is take a little bit of time to examine some of those harmful, unintended consequences of things like residency restrictions. First off, a number of groups have come out in opposition to residency restrictions. I was at a conference in November where Patty Wetterling, the mother of Jacob Wetterling, you may remember the name Jacob Wetterling. The National Sex Offender Registration Law is named after Jacob K. Wetterling. He was abducted. She is strongly against residency restrictions. The National Alliance to End Sexual Violence has stated the following: because residency restrictions cause instability, which may increase the risk for reoffense, the NAESV opposes residency restrictions. The California Coalition Against Sexual Assault, another victim advocacy organization, has stated that residency restrictions are a short-sighted approach to sex offender management that will place California communities in greater danger. The opposition that's been voiced by victim advocates has also been voiced by a number of other people representing a number of different fields. Probably the single best argument against residency restrictions comes from the Iowa County Attorneys Association. That is their group of what we call in our state the prosecutors. They noted that their motives are not brought on by sympathy for those committing sex offenses against children, but by our concern that legislative proposals designed to protect children must be both effective and enforceable. Anything else lets our children down. They noted a number of unintended consequences, not that they theorized, but that they're actually seeing happen in Iowa. One of those is a reduction in confessions and plea agreements, as well as situations where cases have been dropped, basically charges have been dropped for lack of evidence. As a result, they've noted that many sex offenders will go unpunished and will not get treatment. Another thing that's happened, which was brought up by the speakers before me, was that law enforcement in Iowa, in Florida, and elsewhere, where residency restrictions have been enacted, have found that these residency restrictions have caused offenders to become homeless, to change residences without notifying authorities, register false addresses, or simply to disappear. This undermines the sex offender registry, and as a result, it makes it more difficult for the authorities and the public who depend on the registry and notification systems to keep track of where these offenders are.
in sum, and this is in response to a question that was brought up earlier, what's the link between the parole board findings, what parole found in terms of the effect of change in residency and losing jobs and reoffense? Basically what we know is that when you destabilize an offender, it increases the risk that that offender is going to be rearrested or is going to reoffend. Destabilization in housing and employment are two critical factors. That's just the case here in Georgia. In fact, every single night, the parole board uses a risk assessment to calculate the risk of parolees. It does it automatically. Uses 9 factors. 2 of those 9 factors are whether they've moved or whether they've lost their job. So that's certainly true here in Georgia, but it's also true nationwide. It's what we know from correctional science. So the 2 things primarily that residency restrictions have as unintended and I believe unfortunate consequences. The first is that it destabilizes the offender population by requiring changes in residence and changes in employment. And it makes it impossible for offenders to establish themselves in a community where they can get the sorts of support, treatment, good supervision from their probation, parole officers, those sorts of things. The second thing, the second major unintended consequence of these legislative efforts is that it undermines the registry and notification statutes. We've had in place now about 11 or 12 years national and statewide residency, registration and notification statutes that help us keep track of offenders. Those things are useless or made much less useless if we're not sure, if people are moving all the time. What happens is that we have a population of nomadic offenders who are destabilized, and that frankly increases the risk that they're going to commit further crime. Now, a question was raised by Representative Benfield about whether there's been any particular research regarding residency restrictions. There in fact has been. There are 2 particular studies that I'll cite. The first was a study that was conducted by the Colorado Department of Public Safety in 2004. They followed 130 probated sex offenders for 13 months. They concluded that residency restrictions are unlikely to deter sex offenders from committing new crimes, and that residency restriction policies should not be considered viable strategies for the protection of communities. A second study, published in 2003 by the Minnesota Department of Corrections, certainly an agency who would have as its goal the protection of its citizenry. They studied 329 level 3 offenders. Those are the most dangerous offenders, level 3, between 1997 and 1999. Of the 224 sex offenders, they said not one of the 224 sex offenses would likely have been deterred by a residency restriction law. Their conclusion was that residential proximity to schools and parks appeared to be unrelated to sex offender recidivism. They advised that blanket policies restricting sex offender residency are unlikely to benefit community safety. All right, conclusions based on this. First, there is no evidence to support either the enactment or support of residency restrictions as noted in empirical studies and conclusions by the Colorado Department of Public Safety and the Minnesota Department of Corrections. Furthermore, significant experience in the assessment and monitoring of offenders over 50 years has shown us that the more stable the offender is, the less likely he or she is to commit future offenses. Third, residency restriction statutes have a high cost of enforcement and increase the degree of resources required to monitor, track, and supervise a nomadic population of destabilized offenders. And the question I would have is basically the degree to which it is important for this committee to commit significant taxpayer resources to something with no demonstrated positive effect, which may in fact place children at greater risk for victimization.
Thank you. Mr. Setzler, did you have a question?
I did, if I could, Mr. Chairman. Dr. Baldwin.
Pull that microphone a little bit closer to you, not too much closer.
Thank you. Dr. Baldwin, if you could just indulge me with a couple questions. I too have small kids in the home. My big ones, my oldest child is 9. My youngest is about 18 months. And I would ask you, at some age, with your kids, age 12, 13, when your oldest one is old enough legally to watch the younger ones, you leave them to watch the younger ones. You go to the grocery store. That's just sort of part of life. That's kind of how families function. Let's say 2 or 3 years from now, hypothetically. It's Saturday. You and your wife want to go off and do some things in the afternoon and leave your younger ones with your bigger kids. Say the oldest one's 12, 13 years old. But you realize that 2 weeks prior, right next door, right by your swing set in the back part of your yard, that a level 3 dangerous sexual predator has moved in as your next door neighbor. You and your wife reached out to him, said hi to him, introduced yourself, and you found out over the course of this time that, oh my gosh, this person just was in prison for 20 years, multiple dangerous offenses. Would it influence your leaving your kids by themselves in their backyard, unsupervised, if you knew there was a dangerous sexual predator living next door?
If I knew there was a dangerous sexual predator living next door, yes, it would. However, one thing that I advocate is that we have a better understanding of where the true risks are. I know my kids are a much greater risk of being abused by someone I know or one of my relatives. When the U.S. DOJ published a study in 2002, they found that 93% of cases of childhood sexual abuse were committed by someone either known to or related to the child victim. Only 7% of kids said it was by a stranger.
I certainly understand that to be the case because the proximity of kids with folks they know, they're in the same household. Right. There's so many more opportunities for that kind of thing to happen. So statistically, I recognize that. However, the 7% you're talking about is still a significant amount of violations by strangers. And I think the fact that you, an expert in this field, a self-professed expert in this field, this is what you do for a living, that your behavior would be significantly influenced by the fact you've got a dangerous sexual predator living next door just cements the case in my mind that there are concerns about the proximity of dangerous sexual predators to kids, and that this law in itself simply seeks to remedy what you've recognized by your concern of people that live next door to you. So that's just a concern that if you're concerned, I think it would seem that all citizens should be concerned.
And I appreciate that. I am concerned, but my house is not a covered location. So if I'm not living within 1,000 feet of any of the covered locations, then this person can move in right next door to me. There's a great quote in Florida. A guy was made to move because he lived 900 feet from a church where they had a Sunday school class once a week. He was made to move into one of those pay-by-the-week motels. Right next door to him was a family with 3 kids. So the kids at church were safe because he no longer could live 950 feet from the church, but those kids right next door were likely placed at a greater risk. So I agree that protecting children, that's my main goal, but I don't think this is the best way we can do it. I think there are many viable alternatives.
All right, we have a lot of, you have a follow-up?
I was just going to wrap up, Mr. Chairman, that's to the extent you've got families that live in apartment complexes that have pools and playgrounds and those kinds of things. I think that the spirit of this bill is such that they might not enjoy living in a private home that you and your wife are able to live in, but the local playground that has the dangerous sexual predator living next to it is an equal concern for those parents. And I think that's the spirit of this bill, and I would offer that to the committee.
Mr. Levitas?
Mr. Chairman, I'm willing to defer. I think Mr. Beard and handle.
Mr. Beard.
I got a question about your survey study there. Sure. And this is what I was hearing. So you're telling me that this body, by making residential restrictions, we're going to force someone to commit a crime instead of looking at the obvious that they're criminals. They break the law. So under your studies, what we should do is pamper them and just let them run free and not do anything. So maybe we don't disturb them, and maybe they won't break the law. Is that what your survey is telling us?
No, that's not at all what I'm saying.
That's what I heard. That's why I was just checking.
No, that's certainly not what I'm saying. I don't believe that's what what is stated here. What I'm saying is that destabilization of offenders has been shown by over 50 years of research to result in increased risk of reoffense. Here in Georgia, every time a parolee moved, in a study of over 6,000 parolees, his risk for reoffense went up 25%. I'm not saying that we need to coddle offenders. I appreciate the fact that here in Georgia we have tough laws that require long sentences for sex offenders. I think that's a wonderful thing. I think heavy-duty supervision in the community for many, many years with GPS monitoring for high-risk offenders is great. I'm not into coddling criminals. I'm into doing, from a public health, public safety perspective, I'm into advocating what has been found to be effective both here in Georgia and in other communities around the world.
So you agree that we should get the criminals away from our kids, though?
I agree that keeping dangerous sexual predators, the definition of which is something we haven't discussed, but that's in House Bill 1059, away from children to the extent we can is a very, very important goal that I share with every member here.
So that would be a yes.
Yes.
Mr. Levitas.
Do you have any statistics on what the current reoffense rate is on for sexual offenders?
I do. In fact, Mr. Knox, who apparently has left the room, his wife, Michelle Knox, up until very recently was the DOC expert on sex offending. And she has stated on the record that the sex offense recidivism rate in Georgia is between 10 and 15.4%.
Okay. And the proposals that you talked about in the Part A, those are not mutually exclusive, right? In other words, even if we decided to pass this bill, we could still do some of those, or some, any, none of those. Okay. And I'm sorry, I just have to. I'm sorry to cut you off, but I know we're moving. The recidivism rates that you talked about, where an offender moved and it increased the likelihood, those were not compulsory moves, right? Those were voluntary moves.
It was any kind of move. It doesn't make
Right.
a distinction.
So in other words, there's no reason to know whether a forced move would have the same effect because we don't know what the factors are that go into what caused that person to be destabilized and move. In other words, I'm suggesting, isn't it possible that that offender was already destabilized and that the move caused, after they moved, they reoffended, and that there may be factors that cause that person to move. In other words, not the move itself. We may be looking at the wrong causation for what the destabilization is. Isn't that possible?
It's possible, yeah.
Okay.
That's a good question.
And the last thing I want to make sure is when we're talking about the reoffense rates, when we're talking about the study, there's no disaggregated data to say what the causal was. Just it's a statistical link between one person has moved and they have reoffended, but we don't know what the explanation is for that. Is that right?
In terms of the parole study, you're correct. There's no way of figuring out exactly what factors there were. Now, in terms of recidivism of sex offenders in general, there's a large body of literature that looks at the causes of reoffense. And in fact, the largest ever study found that residential instability and employment instability were among the best predictors of sexual reoffense.
Roberta Abdul Salam.
Go ahead.
Thank you, Mr. Vice Chair. Dr. Baldwin, I'm curious to know if there are any studies that can give us an indication of how many predators that are abiding by residency restrictions, but we all know they go into other neighborhoods. There's no restriction on them visiting other neighborhoods as long as it's not within 1,000 feet of, and so therefore they're at risk anyway. I mean, we're all at risk. I'm a victim of sexual assault and rape, and I'm very, very sensitive to this issue. And by the way, I have 6 grandchildren, but I am just very, very concerned. We are with the way that it's drafted and the original 1059 even, and I raised this at that point. We're going to create a host of more homeless people. We're going to create more transient people. You don't know who's in the neighborhood. The sheriffs have no budget increase to be able to track these people. And I think there was something in 1059 about within 48 hours. But my question then and still is, how do the sheriffs know when they come? So I'm just very interested in that. Also, the fact that some of the victims live with the offenders. And we're not able, if they own their house, we're not able to do anything about that. I just, and then we create deadbeat dads. We create more children without fathers in their lives. And probably what would resolve some of that, Chairman Ralston, is if we could narrow down the true predators versus sexual offenders. And I think that might really help. And you know, I want to try to resolve this. I really do. but I have some things that really, really fundamentally concern me. That you're going to put them. I mean, you can restrict where they live, but you can't restrict where they go, and they're just as dangerous in Macon as they are in Atlanta.
The case of Shasta Green in Idaho that was brought up earlier. Basically, someone from another state drove by the home and kidnapped Shasta Green, killed her parents, kidnapped her brother, later killed her brother. The case of Jessica Lunsford in Florida. She was abducted from a car wash. Neither one of those would have been prevented by a residency restriction.
Next question was Representative Stuckey Benfield.
Thank you. Representative Abdul Salam raised the same issue that I had. I recall reading somewhere that there are some studies showing that the majority of sex offenses are committed away from, the proximity where the offender actually lives. So that was my same issue.
60% of sex offenses occur either in the home of the offender or the home of the victim. Those offenders who don't commit the crime either in their own home or in the home of their victim, given, of course, that we know 93% of victimization is if a child has been known to or related to the victimizer. Those that don't tend to go outside of the neighborhood or somewhere where they're not watched, where they're not known, because, of course, they don't want to get caught. It's very secretive. They want to do what they're doing outside the observation of those people who are familiar with them.
Mr. Franklin.
What percentage of sex offenders actually register in the state of Georgia?
That's a great question. I hope that it's all those who are required to. Now, I know that there are a number of cases where they don't register, and I can't speak exactly to how many of those cases that there are. I know of a number of cases where people have registered false addresses. One of the impacts of residency laws is that it tends to increase the degree to which people don't register. In Iowa, after they passed the 2,000-foot residency restriction, in 3 months' time they had a 300% increase in people who were not registering their addresses.
The next person on the list, thank you.
Sure. Thank
Next person on the list, Mr. J. Tom Morgan. My good friend and former colleague from DeKalb District Attorney's Office, former District Attorney of DeKalb County, noted author and children's author. You want to get a plug for your book while you're here? What's the name of that book? I asked for just him to sign the book, and he said that I would have to pay for the book.
Chairman Munford, Chairman Rawson. First, let me say I'm not here on any behalf of any group, organization, or individual. I'm just someone who has some personal knowledge, professional about this particular subject matter. In 1984, I was appointed the first prosecutor in Georgia to specialize in the crimes against children. I did that for 9 years. I'm a founding member of the Georgia Center for Children, which treats victims of child sexual abuse, and a founding member of the National Children's Allowance, which has over 1,000 organizations now which serve children who have been sexually abused. First of all, Chairman Ross and I have known each other for many years. We have also been classmates together, and he has been an advocate for children during his entire public service career. He has supported legislation on behalf of the prosecutors of the state and children, and we're very appreciative of that. I have two concerns about this piece of legislation. First is constitutional, and the second is procedural. From the constitutional respect, and Chairman Rawson did much better in constitutional law than I did, but I do recall there has to be a rational basis between the government interest and the deprivation of the private liberty and property. I have concerns whether this legislation will pass muster in federal court. As you've already heard, there is a case now that on this very particular issue. The rational basis is this. Does this legislation serve the purpose? Let me just give you a couple examples. You've already heard that the child is in far greater danger from being molested and sexually abused in their own home or in someone else's home than by someone who lives close to a school, or lives close to a church, or lives close to a child care center. Let me just say, I never prosecuted anyone who molested a child because they live close to a church. I have prosecuted a lot of people who work in a church. I never prosecuted anyone because they live close to a school. I have prosecuted people who work in the school. There has to be a rational basis. I do not see the rational basis here. I'll just give you a case study. Years ago, I prosecuted a young man, 20 years old, for having consensual sex with a 15-year-old. Not wise, he violated the law. I prosecuted him. He was sent to prison. He served his parole and probation, but he is now a sex offender. He is in his 40s. He lives in Augusta, Georgia. He moved in with his father, who is a retired general. His father called me in October. They moved the school bus stop within 1,000 feet of his home. So now he has to leave his residence. He works in downtown Augusta. He works within 1,000 feet of a church. That church is closed Monday through Saturday. The sheriff came to see and said, you can no longer be employed by your employer because you work within 1,000 feet of a church. Now, there are no children at that church while he is at work, and there's nothing in this legislation from prohibiting him to attend that church on Sunday, but he can't work close to that church. I am very concerned as to what a federal judge is going to say, where is the practical, rational basis in this legislation? I am all in favor of the sex offender registry. As a parent, as a citizen, I want to know where sex offenders are living. I think it's helpful to us, but I want to know what type of sex offender. And I've certainly, as David Ralston has already pointed out, Chairman Ralston has already pointed out, maybe we need to look closer and to define sex offender. There are dangerous individuals in our society. We should not be around children, but they are a small minority of the population that is painted with this broad brush of being on the sex offender registry. But while you're talking about it, not only do I want to put their sex offenders in our neighborhood, I want to know if somebody's committed murder, somebody's committed aggravated assault, somebody's committed DUI. I am a lot more concerned about the care of my property and the safety of my children from a DUI driver than a convicted sex offender. So while we're looking at this legislation, I think we need to step back and say, can you tweak this legislation so it passes constitutional muster and that we do not include everybody who's been convicted of a sex offense in this bill? Thank you.
Thank you. Mr. Franklin, do you have a question?
Yes, sir, if I could. Did I understand you right in the example you gave that the male that you illustrated with was convicted of having consensual sex with a 15-year-old? What is the age of sexual consent in Georgia?
16.
So a 15-year-old cannot legally consent to sex, is that correct?
That's correct.
So he did not have consensual sex, is that correct?
No, he had consensual sex. He did not have force and against the will. Now, he didn't commit rape, but it was with the consent of. Now, you can go to a legal definition. Did he rape her? No.
But a 15-year-old cannot give consent.
15-year-old by definition cannot give consent.
Thank you.
But there's a difference between legal definition and practical definition.
Thank you very much. Next, we have James Stark. Mr.
I have a report from the field.
Mr. Stark, if you'd come around here so we can see you. Just come right here to where Mr. Morgan was.
Okay, well, as I was saying, I have a report from the field. I've been a therapist in the area of sexual abuse for 37 years, seeing hundreds of children and seeing hundreds of offenders. I think that we need to pay really good attention to who is what level. The Sex Offender Registration Review Board is a very powerful part of this bill. We need more people on that bill. We need to categorize all 15,000 of persons now on the registry. And I understand 100 or 200 people a month come out of the prisons. They need to be categorized so we know who is living next to us. If you look on the GBI website, I think there are 39 or 40 people who are called dangerous sexual predators. And so when I hear people loosely referring to predators, I think many times they're talking about all sex offenders, and that's not true, because they're all predators. Very few are predators. A number of states have enacted residency restrictions, and to my knowledge, there's no proof that they really work. Many sex offenders didn't even have interactions with children. It's wrong to say that all sex offenders are child molesters. some that keep through lenders, some that engage compulsively on the internet sexually. But not all of those abuse children. We have a tripartite system of control already operative in the state, where these individuals who are coming out of the court system and out of prison have a probation officer who supervises them. They have surveillance officers who go out to the home. They're in treatment programs such as ours, and we have polygraphs every 6 months. I don't think the general public knows this. I have the impression that the general public is just loose out there, they're running fancy free, but they're under a great deal of control. We need the level system. It was in 1059, and that's great, but it's essentially inoperative. I received the first copy of a letter the other day that went to one of the people in our program, indicating that he had been given a classification, and our program has been going for years, so that board needs beefing up. There are 2 or 3 vacancies. Those vacancies need to be filled. I think we need, instead of a 15-member board, a 30 to 45-member board, so we can get on the stick and measure and assess all 15,000 of these folks, so we know what we have, and so what we know, so we can know what to do. If we can put a missile through a window in Baghdad, we ought to be precise about treating sexual offenders, level 1, level 2, and then sexually dangerous predators. There's a great deal of misery amongst the families of these people. There's misery with people having to relocate. We deal with these people every day. We know what they're going through. It's not going to help protect our citizens if people who used to offend are in a miserable state. One more comment concerning the law and the notion that individuals who own a home can stay there, but those who don't can't. That sounds like a poll tax, very similar to a poll tax. And I think somebody at some point is going to look at that and say, you mean if you have money to own a house, you don't have to do certain parts of this law? Okay, if you do have money to own a house, that you're exempt from things. I think that some people, some judges somewhere are going to be questioning that, so you can see that coming down the pipe. So I'll close with a notion that we already have a sexual offender registration review board. It only has 13 members. There are 2 vacancies. We need to fill those. I think we need 40 or 50 people on that board, and we need to get on the stick and evaluate all these 14 or 15,000 registered sexual offenders, so we will know really what we have. Currently on the GBI site, it says we have 40 sexually dangerous predators. And it's all this hubbub about this.
Thank you very much, Dr. Stark. Next, we have on our list Priyanka Sinha. Did I pronounce your name correctly? Wow.
Vice Chair, Chairperson, members of this committee, thank you for this opportunity. I'm Priyanka Sinha. I was a victim advocate at an organization called Raksha, serving the South Asian community. I'm also a member of a coalition called Transformative Justice Collaborative, which is specifically looking at the issue of child sexual abuse as our problem, as a family problem, and one that we're not going to get rid of by moving and driving sex offenders out of our communities and our neighborhoods. So we're really focusing on the issue as a family and intimate network issue. We believe that HB 908 deflects from the real problem. It pushes resources away from the real issues that exist within our community, which is the fact that offenders are within our own intimate networks, visiting uncles, stepfathers, siblings. It creates an atmosphere of stranger danger. Again, pointing fingers to the issue of stranger abduction, when really child sexual abuse is an issue that affects us within our own intimate networks. And also what we believe is that it really further pushes underground those who offend and makes it harder for us as victim advocates, as those who are parents, as teachers, and also civic leadership organizations to think through appropriate strategies to actually prevent the issue of child sexual abuse. If we are not able to serve families because they are underground. If they're not able to have access to victims or even those who are in relationships with victims within the families, it doesn't make our job easier. So as a concerned community member, as a mother, as a part of this collaborative as well, I urge this committee to really think through all the statistics that we've heard, the real issue of child sexual abuse, which is in our networks, and the fact that this really deflects from the real problem. I think everybody has really spoken to the realities of this issue, and I, you know, for one, as an individual who sees the ways that offenders are driven into poor communities and communities that have no resources, I want us to look at that, the race and class issues behind this, and we believe that HB 908 won't take care of all of this. And so I urge the committee to have a larger view of this issue rather than this is going to affect me, this is going to affect my household, when really we should all be thinking about appropriate strategies to prevent child sexual abuse. And that's what I have to say.
Thank you very much. Mr. Scott Berry, Oconee County Sheriff.
Mr. Chairman, Mr. Vice Chairman, and I just want to speak on behalf of the Georgia sheriffs across the state who gladly accept the responsibility for keeping up with these sex offenders and predators that are released back into our communities. I want to thank you, Mr. Chairman, for this piece of legislation. One of the people spoke before me said that they had a vested interest in this. What they don't have is a vested responsibility. That belongs to us.
Got a meeting. Do you need
That belongs to y'all. We have a vested responsibility. And a lot of people concerned about sheriffs and whether we budget and funding things. This is my show and tell. This is Dixie County knowledge. He does that in Oconee County, Georgia. And we gladly accept this first. And I want to tell you that on behalf of 159 sheriffs. And we appreciate the chairman's legislation. Thank you.
Thank you very much, Mr. Sheriff. Sandra Michaels.
Thank you, Mr. Chairman. Sandra Michaels for the Georgia Association of Criminal Defense Lawyers. Our association has worked with Southern Center and others. Many of you know Doug Peters, who spoke very eloquently here on the first bill, House Bill 1059. We defer any litigation requests or arguments about specifically House Bill 908. I've spoken to bar groups around the city, around the state. Often J. Tom Morgan has been there. And we hear from judges, prosecutors, law enforcement, providers for rehabilitation, and certainly from the community about their concerns the original House Bill 1059 raised. I think the Supreme Court decision gave a great opportunity for this committee, whose well-meaning attempt in 1059 has apparently raised a lot more concerns and harms, as you've heard today. And I'm sure your prosecutors, judges, and sheriffs have all contacted you about things they would feel that 1059 could better address. And I respect very deeply Chairman Ralston's suggestion that a new bill be prepared to address those concerns. The opportunity right now for this committee to readdress these issues in an honest and good, well-meaning way, which every person up here has spoken to you about, with very valid concerns from experts in this field, people that do the work. This committee, members of this committee, I know represent Benfield. J. Tom Morgan has been no slouch in the prosecution world whatsoever. I know I've had numerous cases involving his office. These cases are very difficult. I certainly defer to his expertise in what the original House Bill 1059 lacks in proper prosecution, registration, and as many of the other witnesses have said, a real legitimate look at safety for our community. And I would respectfully request this committee to take a look at the whole piece of legislation and not just focus on this one.
Thank you very much. All right, I had someone wanted to make a motion. Mr. Franklin.
Mr. Chairman, I move do pass House Bill 908.
Is there a second?
Second.
All right. All those, is there any further discussion on the bill? I believe that's what the motion was. LC 293039S, is that your motion?
If that's the version that the chairman is working off of. Then that is my motion.
What is
by,
that?
By
Is
substitute.
that a committee substitute? Committee substitute. That's been the motion. All right. Is there discussion on the motion? Ms. Abrams.
I want to laud Chairman Ralston. I appreciate and deeply respect the integrity of the intent behind this legislation. However, I wanted to explain that I am concerned that this legislation and its predecessor exacerbate an issue without providing an adequate solution and actually place victims in deeper harm. I appreciate the opportunity that we will have in this committee to perfect the sexual offender registry and associated legislation, but cannot support legislation that, from the research and from those advocates, both on the law enforcement side and on the defense side, seem to suggest that this actually places families and children in greater harm.
Thank you. Mr. Setzler.
Thank you, Mr. Chairman. To the author, Chairman Ralston, I just wanted to, again, thank you for bringing the bill. We've heard a lot of testimony on this over the last two sessions when we passed 1059 and some of the discussion we had around that, plus this. There's been a lot of critics, and I appreciate some of the criticisms. I hear things, and it seemed to make sense at face value, but I would share with the committee that I've not seen a comprehensive package presented by anyone that says I have a better comprehensive plan to solve this issue than what Chairman Ralston's presented. There are a lot of critics, and I would, knowing the chairman, would submit to the committee if there was a comprehensive plan that, on its whole, solved this problem better than what's being presented. He would have incorporated parts of it or incorporated it in whole. I've just not seen a comprehensive approach to better protect children than what's been presented. And until such things presented to this committee, I think this is the best plan moving forward. Things can always be perfected, but I'd like to thank Chairman Ralston for bringing 908.
Thank you very much, Ms. Setzler. Ms. Byrd.
Yes, thank you, Chairman Ralston, for bringing this piece of legislation. As discussed last year, we are always talking about the rights and statistics for the criminal and never the rights of the victim. I applaud you for doing this, and maybe what we should do is address the issue of not releasing those perpetrators. Thank you.
All right. One other member wanted to make a comment.
I want to thank Chairman Ralston as well for working on this legislation. I think that it is a very good effort. There are concerns. It is not criticisms that I have. There are concerns, and again, being a victim, one of those victims that Representative Byrd talks about, I have a little bit more sensitivity to it. One of the things that I'm concerned about is that it doesn't just cover children in this bill. It's all people. And right now, everybody that's accused and convicted is on that sexual predators list. Everybody. So for that reason, I do have concerns, Mr. Chairman, and I will not be able to support as is.
Thank you. Mr. Chairman, did you have any last comments you wanted to make?
Thank you, Mr. Chairman, and I appreciate your conduct of the meeting, and I think all of those have addressed the committee. Whether they agreed with the bill or not, I have a great respect for them, and I appreciate all of them. Let me touch on 2 points very, very briefly. Number one, there was a lot of talk about whether there have been studies or not, and when we do try to approach these things in an analytical way, looking at evidence, but I would remind the committee that this bill, these restrictions, have been the law in the state now for less than 2 years. And while I do try to be analytical, because that's kind of the way I'm supposed to make my living back in my other real job, I don't know of any studies here in Georgia. The only study I can share with you is that I've not had one sheriff, one district attorney, one chief of police, one judge, one mama, one daddy, one grandparent asked me to repeal this bill. Now, I'll share that with you for whatever it may be worth. And I live in a small town. People stop me all the time, and they're not afraid to give me their opinions on what we do down here. The lady that cleaned my office reminded me Sunday afternoon, do not ever let a sex offender out of jail. And she talks to me about that every month or so. So I'm not going to say that there are studies for or against it, but this thing hasn't been allowed, in my view at least, adequate time. There was the other thing I want to comment on is there was some talk about destabilization and inconvenience and all that sort of thing. Well, when I was taught that our actions have consequences. Bad actions have bad consequences. Otherwise, why would we have a criminal code? And there are things in there that are called punishment. If you commit a DUI, what happens? You lose your license. Well, somebody's going to be inconvenienced. You don't pay your child support, you lose your driver's license. So I think it's important that we have to understand that when you sexually abuse a child or another person, there's just going to be a little inconvenience with that, and I think that's what society expects. And so I don't apologize for that. If you believe in, there's a lot of discussion about the validity of these restrictions in their entirety, and people, saying, well, maybe we should never have done them, and they don't like them, and I respect that. If you want to repeal them, vote against this bill, because we don't have any now. There is nothing, as we sit here today, to stop a sexual predator or sexual offender from moving in next to the daycare center that Representative Ramsey left his children at this morning. So doing nothing today allows that to happen in the state of Georgia. And it's just about that simple, and I would ask for your support on this bill.
Thank you. All right, we have a motion do pass on LC 293039S, a committee substitute. We're ready for a vote. All those in favor, please raise your right hand. All those opposed? All right. What was the tally? 9-3. Passes 9-3 for do pass. 9-4. Ladies and gentlemen, I believe that concludes the business of the committee. I would remind the members that I believe we're supposed to be in the chamber at 1 p.m.